You're listening to The Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. This series is hosted by litigation attorney Dan Small. Listeners of this series will gain a fresh perspective on how attorneys can address various trial preparation issues and set themselves up for success in and out of the courtroom.
Welcome back to the Trial Lawyer's Handbook podcast. I am delighted to welcome back Eric Alexander, who's a great trial lawyer in our Washington, D.C. office of Holland & Knight and the team leader of the Product Liability Life Sciences team. Eric, welcome back to the podcast.
Thanks for having me, Dan.
We talked last time about trials and younger lawyers and how we develop, but now I want to tap into the knowledge that you've gained from these product liability cases. First of all, if I should set the stage, talk to us a little bit about a product liability trial. How is that different from what someone might see on Law and Order or wherever they get their information?
Well, it definitely is different than criminal trials. I will start with my admittedly biased view that these tend to be hard cases to try because you typically have an injured person who usually is from where the jury's from, unless you're doing an MDL trial when both sides have waived lexicon, not to get too technical, and you represent a big company from somewhere else that maybe doesn't have the best reputation in public. No matter how many life-saving medications they made, no matter how many great devices they made, people don't like how much drugs and devices cost. People have a lot of press out there and manipulative online advertising, other things that might influence jury perception. So I think you really start in the hole with those cases defending the companies. The other part of it is, we usually say about these cases, you win on the case specific, but you lose on the generic. And what I mean by that is, if you're ever going to win one of these cases, you need to have something where you're like, hey, we didn't hurt this person. This is completely unrelated. You need to have a good story about, hey, this drug doesn't increase the risk of the problem they have. They had it for an everyday obvious reason. But if the jury gets mad at you and your client because of all the liability stuff, then you're going to lose. So part of the job, I think, and it's been my focus in a number of trials and litigations, is to help diffuse the bad guy image. You can't always just hide behind FDA's skirts, so to speak, and that's increasingly so. But these typically are approved or cleared devices and drugs. The company's typically going to have a pretty good regulatory compliance story. They're going to have a bunch of legitimate scientists working for them who really care about the improvement of the medical conditions that they're addressing with their products. There's just so much of that sort of sideshow that is going to get in that you as a defense lawyer in a case like this have to do enough to let the jury focus on the things that you think really matter without getting so angry at your client that they're not going to listen to anything you say.
We had a trial recently where, not a drug case, it happened to be an employment case, but I said to our client and their representatives, you are right on the law, you are right on the facts, but you are going to lose unless you can get the jury to like you. And they're like, what? Why is that such an important part of the trial? I said, it's not an important part of the trial. It's the only part of this trial. And as you know, I do a lot of work preparing witnesses and wrote the ABA's manual on it. We did a lot of work with them just on that. You know, you can't be a robot. You can't be a bureaucrat. You got to be you. And in the end, it worked. Have jury dynamics changed in the last 10, 20 years? What do you think?
Oh, yeah. I think that the changes have been accelerated over the last 5.5 years, which correlates to the beginning of COVID as a pandemic and the shutdowns associated with it. But that accelerated some things that I think were going on already. A couple of things in no particular order. People, because of the internet and because of social media, are increasingly suspicious of experts and don't rely on experts solely because of their credentials. The kind of do your own research crowd, we sometimes call it the death of expertise. People are like, well, I understand this stuff. I don't need to have a PhD to understand the particular issue here. And that generally works against defendants because you're usually on the side of science and what the right interpretation of science is. That's changed. I think people defer to experts less based solely on their credentials. I think that juries are less likely to be deferential to FDA in particular, other government agencies, but FDA in particular. And that definitely started before this calendar year. That was driven by a number of COVID dynamics. But again, I think it was in place already, just sort of this independent thinking that goes on. I mean, I've had jurors in jury selection say things like, well, if this is an FDA approved product, I'd be less likely to think that it's safe. So that's a change. I mean, I think it used to be you're like, hey, I got this person who got their MD from Harvard and they have a full professorship here and they're really an amazing expert. You're not necessarily going to get much traction with that person unless they're also really good at explaining and maybe, like you said, sufficiently personable and likable that the jury wants to believe them. But I think it's harder now than it used to be.
So talk to me a little bit more about experts. How do you prepare your expert given that environment and given the challenges they face?
Well, obviously it starts with who you pick, right? You pick somebody who's good, who's personable, who's certainly legitimately qualified, that doesn't have significant baggage. All of that is true. You realistically evaluate your needs for the case or the litigation in terms of who your experts are, how their opinions fit together, avoiding conflicts, all of that. And then what you're thinking is like, you got through the DEP, you got through the Rule 702 motions, you're at trial. In my typical posture, the other side's gone, they've rested their case, or they're about to rest, and I'm preparing our expert who's going to lead off and say, version of the My Cousin Vinny opening, everything the other side said was expletive deleted, depending on your rules. I don't really know, Dan. How do you get that guy or that person ready? And again, that involves being able to be honest with them. I do mock crosses, I do mock directs. I typically scope out direct, do a hard mock, go through direct again with fine tuning to account for things that were successful or not in the mock, and invite them to come back with, oh, I need to redo that area. I think I can do better. But in the middle of that, you have to be able to say, not that you're coaching the substance of answers, you have to say, that wasn't so great, that part that you did, or this goes for all the witnesses. We were just talking last time in connection with the jury's eyes on you. Where's the witness looking when questioning's happening from either side? How respectful is the witness of the judge and the court staff? I had a witness I put on a couple of trials who has 3 doctorates, a couple of masters, absolute world expert in his field, a genius, a great expert. But the best part is when you get him to stand up and teach and talk like a regular person. And listen, I think that is part of what you have to do. Again, your honesty about you and your witness and how you come across and how your dynamic is. Figure out where they're best. Are they best on their feet as a teacher? Are they best in the box? Are they a little too stiff? Can you loosen them up? And that has to come out from your prep, where you try different things and you go through different ways of conveying your message. And of course, listen, we all know you can't have a dramatically different demeanor on cross than on direct. And we know that you better know how to get impeached in addition to, as the lawyer better know how to impeach. I think the vibe, the feel, hey, this person's incredibly qualified, but I also kind of like her. And I think maybe I understand that. I wasn't talked down to. I was allowed to get enough information to connect the dots myself. Juries like to connect the final dots and not have it all spelled out for them. But that's an assessment of the witness. Maybe sometimes you videotape them and you show them the video. Maybe you just give the feedback. But you have to start from the beginning of picking somebody who you think is going to be able to take that sort of direction or guidance at trial about, like, you're not talking to third-year medical students here, dude. We need to dumb it down a little bit. Let's stop the alphabet soup. A lot of people don't want to hear that. They're going to be like, I know what I'm doing. So I think there are a lot of parts of what I just said, but it does come down to, as a lawyer, it's not the words on the page. It's not the degrees on the CV. It's the ability to convey the message to the jury and then have it stand up during cross.
No, absolutely. We just had a case where we had an absolutely brilliant MIT PhD physics professor as an expert who did a brilliant report that really turned the case on its head. But when trial counsel was moving forward towards depositions, they realized that he was accustomed to speaking with other brilliant MIT physics professors. And they called me in to basically teach him English. And he knew English very well, but a juror's English. So let me just quickly, I want to transition to corporate witnesses, Rule 30b-6 or whatever the rule is. Most of your cases, you have a corporate witness. Is that right?
Yeah, usually the plaintiffs try to present the corporate case through video depositions. Judges sometimes allow that. Sometimes they're like, hey, if they're available, they can be presented, and I prefer that they be live so I can rule on it. Going through deposition transcripts with counter designations and objections is a giant time suck for judges.
And torture for the lawyers, I should say.
Oh my God, yeah. Mostly they like a video show because their view is that the witnesses will be better prepared at trial than they are in deposition, and that a lot of lawyers make a mistake, from my perspective, in terms of not getting good testimony from their own witness at a deposition. I don't think there's anything called a discovery deposition in the world anymore. Every corporate employee who's deposed, in one of my cases, every third party who's deposed, I mean, that's potentially trial testimony. So you got to be ready up front. But at trial, we often present somebody as a corporate witness who put a nice face on the company. Sometimes that'll be somebody the jury's already heard from via deposition, if the judge is letting plaintiffs do that and won't force them to decide. Just ask your questions, the person's coming live, and then you have to deal with a lot of scope issues. But it is as simple as putting a good face on the company is job one.
That's great. No, absolutely. Eric, you've been very generous with your time. I appreciate it. Any final thoughts for our trial lawyers listening?
I'll go back to something we talked about last time, which is the young lawyer, what lawyer you might become when you start out and you finally get your chance in the typical big law kind of context, finally get a chance to do an important witness at a trial. You're standing up, you're there. I think that smart, well-prepared, confident lawyers can do a good job with opposing super qualified, really experienced experts. I think that that's one permutation of it, but it translates to, if you can find the confidence, not overconfidence, but if you can find the confidence, you have the technique, you have the knowledge, I think that the young lawyers should know that they can get it done and know that they can, over time, develop enough of their own shtick, their own ability to stand up and be who they are and be effective at trial instead of being scared and formulaic. I will tell you that I don't like formulaic directs and crosses in a lot of ways. I don't agree with the idea that you can't win your case and you need to rein it back. But I think that you start with the idea that scoring points by being aggressive, even with the other side's witness, by establishing really important things under a difficult context, is a possibility. And I hope young lawyers are emboldened to, with appropriate CYA, take some chances in there and at least think about, is there a way I can get something really helpful to win this case, as opposed to, well, I'm just going to ask so-and-so a couple questions. That's selling yourself short. And I would encourage the lawyers out there, particularly on the defense side, people representing companies getting sued over product liability and other kind of big serial litigation, that sort of thing, that you don't have to just play it safe and you don't have to be overly cautious all the time.
Great advice. Eric Alexander, team leader of Holland & Knight's Product Liability Life Sciences team, and I can use the word extraordinary trial lawyer and teacher of trial practice. Thank you so much for joining us on the Trial Lawyers Handbook podcast.
Thanks for having me, Dan.
Thank you for listening to the Trial Lawyers Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. For more information on courtroom preparation, please email dan.small@hklaw.com or visit hklaw.com/Dan Daniel-Small.